I, Anjali Bansal Goyal, Assistant Professor, Punjab University, is giving presentation on equality, Part 3, Article 17 and 18. The caste-based Indian society has defined a particular code of conduct to persons belonging to every caste. In Hindu society, the most powerful instrument in determining a person's dignity is his caste. Caste system is the result of the Hindu belief of reincarnation and karma. The Hindu religious code of conduct divides the entire society into four major castes, that is, Brahmins, the priestly class, Kshatriyas, the warrior class, Vaishyas, the trading class, and the Shudras, the servants. The four castes eventually developed into a social mosaic of 3,000 subcastes, with the untouchables at the bottom of the list and out of the list in particular. Thus, birth decides the occupation of the person. This caste system discriminates the human persons and stratifies them into different groups. Understanding the nature of Indian society and the caste system before independence is essential to study the contributions of Ambedkar to law and justice. In the light of peculiar social system existed in India before independence, Ambedkar has proposed several remedial measures as well as laws to address the exploitative social system and also to bridge the gap between various castes or social groups in the country. Hence, the present paper is an attempt to analyze the social system existed before independence and the Ambedkar's contribution to deal with this situation. In this kind of society, many reformers right from the Gautam Buddha have worked against the caste system and untouchability. He challenged the validity of caste and Brahmanism. Meanwhile, other social reformers like Mahatma Jyotirao Phule, Sahu Maharaj, Kabir, Sant Ravidas, Shri Narayan Guru in Andhra Pradesh and Pothuluri Vera Brahman are the social reformers who fought against the evils of Hinduism. The movement they led was not given required relief to the victims of the caste system and patriarchy. After studying all these experiences, Dr. Ambedkar declared that it is not possible to eliminate untouchability in isolation without destroying the caste system, which in turn means destroying Hinduism, and embraced Buddhism on October 14, 1956 along with more than 5 lakhs followers. Hence, Dr. Ambedkar's approach towards the caste system, untouchability and patriarchy is entirely different from other social reformers. Ambedkar proposed equality and fraternity in consonance with the principles of democracy. His entire vision is to uplift the disadvantaged sections of the Indian society through practical means. We will see the results of the struggle by Dr. Ambedkar that many of untouchables have reached highest position. For example, K.R. Narayanan becoming first Dalit President of India, Justice K.G. Balakrishnan becoming the first Chief Justice of India is the small fruits of the trees planted by Dr. B.R. Ambedkar. Ambedkar became the most eminent leader of the historically disadvantaged sections of the Indian society and was instrumental in the formation of the Scheduled Caste Federation. In the pre-independence political sphere, he made an articulate case for recognizing the socio-economic exploitation that had been suffered by those outside the caste system. However, he never chose the path of agitationist politics and instead relied on reasoning and on an appeal to moral values. When India earned its independence, Dr. Ambedkar chose to work with the Congress party and served with distinction as the chairman of the drafting committee in the Constituent Assembly and later as the first law minister of the Union of India. In his later years, he gave up his position in the Union Cabinet on account of the government's reluctance to reform family laws, which were aimed at combating the entrenched gender and caste-based discrimination in private relations. Ambedkar provided constitutional guarantees and protections for a wide range of civil liberties for individual citizens, including freedom of religion, the abolition of untouchability, and outlawing all forms of discrimination. Ambedkar argued for extensive economic and social rights for women and also won the Assembly's support for introducing a system of reservations of jobs in the civil services, schools and colleges for members of scheduled castes and scheduled tribes, a system akin to affirmative action. India's lawmakers hoped to eradicate the socio-economic inequalities and lack of opportunities for India's depressed classes through this measure, which had been originally envisioned as temporary on a need basis. The Constitution was adopted on November 26, 1949 by the Constituent Assembly. Untouchability. The Constitution was adopted on November 26, 1949 by the Constituent Assembly. Untouchability. Untouchability is a direct product of the caste system. It is not merely the inability to touch a human being of a certain caste or subcaste. It is an attitude on the part of a whole group of people that relates to a deeper psychological process of thought and belief invisible to the naked eye, translated into various physical acts and behaviors, norms and practices. There are various legislative provisions dealing with untouchability like the Constitution of India, Untouchability Offences Act 1955 and the Protection of Civil Rights Act 1955. Article 17 of the Constitution abolished untouchability and forbids its practice in any form. It further declares that the enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. The subject matter of this article is not untouchability in its literal or grammatical sense, but the practice as it has developed historically in India. Thus, it was a product of the Hindu caste system, according to which a particular section amongst the Hindus had been looked down as untouchable by the other sections of that society. Article 17. Article 17 states that untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. Article 17 of the Constitution had abolished untouchability as well as its practice in any form. Untouchability means the practices evolved as a social restrictions in sharing food, access to public places, offering prayers and performing religious services, entry in temple and other public places, and denial of access to drinking water sources, etc. The Parliament had enacted the Untouchability Offences Act 1955 in order to implement the mandate of Article 17. This Act contained a significant provision that where any of the forbidden practices is committed in relation to a member of a scheduled caste, the court shall presume, unless the contrary is proved, that such act was committed on the ground of untouchability. The punishments awarded under the Untouchability Offences Act 1955 were not adequate. Therefore, a committee was appointed by the Government of India in April 1965 under the chairman of Shri Ille a Perumal to study problems of untouchability vis-a-vis the working of Untouchability Offences Act 1955 and to suggest changes therein. The committee's report was submitted in 1969. In 1976, the Parliament amended the Untouchability Offences Act 1955, which was renamed as the Protection of Civil Rights Act 1955. Definition of civil right has been prescribed under section 2A of this act as the expression civil right means as any right accruing to a person by reason of abolition of untouchability. All offences relating to the practice of untouchability have been made non-compoundable. Every offence under the Act is a cognizable offence, that is, a police officer can arrest the accused without warrant. For summary trials, procedure is simple and so the case can be disposed of expeditiously. Privately owned places of worship have been brought within the purview of the Act. Preaching of untouchability or its justification has been made punishable. The state government must take measures to make the rights available to the persons subject to any disability, and various measures have been provided under this Act. Such measures include: first, provision of adequate facilities including free legal aid to avail oneself of such rights. Secondly, setting up of special courts. Thirdly, appointment of special officers for initiating or exercising supervision over prosecution. Fourthly, setting up committees to assist the state government in formulating or implementing such measures. Fifthly, provision for periodic survey of the working of the Act. Sixthly, identifying untouchability prone areas and adopting relevant measures to eradicate such practices. Judicial attitude. In People's Union for Democratic Rights versus Union of India, a writ petition has been brought by way of public interest litigation in order to ensure observance of the provisions of various labour laws in relation to workmen employed in the construction work of various projects connection with the Asian Games. The basis of this public interest litigation was a letter written on the basis of a report made by a team of 3 social scientists who were commissioned by People's Union for Democratic Rights for the purpose of investigating an inquiry into the conditions under which the workmen engaged in the various Asiad projects were working. The court held whenever a fundamental right contained in Article 17, 23 or 24 was being violated by a private individual, it would be the constitutional obligation of the state to take necessary steps to interdict such violation and ensure that such person should respect such right. The state is not absolved from its constitutional obligation even if the aggrieved person could enforce his invaded fundamental right. In state of Karnataka versus Appa Balu Ingel, the respondent was convicted by two lower courts on the charge of restraining by show of force the complainants from taking water from a newly dug up bore well on the ground that they were untouchable. The High Court, however, acquitted the accused, believing the evidence deposed by the four witnesses who were all Harijans. The Supreme Court, in appeal, upheld the conclusions of the lower courts and held the prosecution evidence did not suffer from any infirmity and was sufficient to prove the charge beyond reasonable doubt. The Supreme Court expressed its concern over the continuance of the practice of untouchability. It is being practiced with impunity irrespective of the fact of its abrogation. It is imperative to deal with the problem from sociological and constitutional perspectives and also from the perspectives of psychological point of view. The court further observed that the evil of untouchability was not founded on mens rea and therefore the court should adopt a psychological approach in appreciating the evidence and should not be influenced by deep-seated prejudices or predilections covertly found in other walks of life about this evil. In state of MP versus Ram Krishna Bhalotia, the constitutional validity of certain provisions of the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989 was challenged. Section 18 of this Act excludes the operation of Section 438 of the Criminal Procedure Code 1973, which confers discretion on the High Court and Court of Sessions to grant bail in case of non-bailable offences to prevent the commission of offences or atrocities against the members of the scheduled castes and the scheduled tribes and for providing the special courts for the trial of such offences and for the relief and rehabilitation of the victims of such offences. Parliament enacted the Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989. Section 18 of the Act excludes the application of Section 438 of the Criminal Procedure Code 1973 to cases arising under the Act. The Supreme Court upheld the validity of Section 18 of the Act in the present case. In state of Kerala versus Chandramohanan, the Supreme Court held that as regards atrocity committed against a Hindu SC/ST who had converted to another religion, laying down the broad proposition of law, the Supreme Court ruled that a converted person would not cease to be a member of SC/ST community if he was following the customs, rituals, customary laws of succession, inheritance, marriage and other traits required to be followed by the members of that community. In state of UP versus Ram Sanjeevan, the Supreme Court held that it is absolutely imperative to abolish the caste system as expeditiously as possible for the smooth functioning of democracy based on the principle of rule of law. Abolition of titles, Article 18. Clause 1 of Article 18 abolishes titles. It prohibits the state from conferring titles except military or academic distinctions on any person, whether a citizen or a non-citizen. Clause 2 of Article 18 prohibits a citizen of India from accepting any title from a foreign state. Clause 3 prohibits a person not being a citizen of India but holding any office or trust under the state from accepting any title from any foreign state without the consent of the President. Clause 4 further prohibits such a person from accepting any present or office of any kind from or under any foreign state without the consent of the President. Clause 3 and 4 has been added with the view that a person not being a citizen of India should remain loyal to the state and should not commit the breach of trust reposed in him. Whether the awards Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri, known as the national awards, are titles within the meaning of Article 18, Clause 1 of the Constitution of India or not has been discussed by the Supreme Court. And the Supreme Court held that Article 51A of the Constitution speaks of the fundamental duties of every citizen of India. In this context, we may refer to the various clauses of Article 51A and specifically Clause J, which states that every citizen should strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement. It is therefore necessary that there should be a system of awards and decorations to recognize the excellence in the performance of these duties. Thus, giving of such awards is also permissible under the Constitution. The object is to establish an egalitarian society woven into the ideal of social justice enshrined in the preamble to the Constitution. Even though caste-based discrimination and violence still remains a fact of life in today's India, there has been considerable progress for the historically disadvantaged sections of society. Numerous political parties have emerged on the strength of voters from the oppressed sections, and the benefits of education and economic development have also been gradually reaching this section. The attainment of genuine equality is of course a gradual process and may be several generations away, but it was Dr. B.R. Ambedkar who set us on this path with the written constitution. It is not surprising that the invocation of his life and contribution continues to be a major factor in political mobilization even today. The main aim of Dr. B.R. Ambedkar is to uproot the evil of deep-rooted caste system and to transform this country from uncivilized state to civilized state. The Indian Constitution is evolved as a result of Dr. B.R. Ambedkar's efforts and strategic approach to the system. The provisions made by Dr. B.R. Ambedkar by fighting against British rulers and the articles included in the Constitution of Free India enabled Dalits and women to present-day developed state. The all-round development of disadvantaged groups in India is only because of Dr. B.R. Ambedkar. Today's tragedy is that the rulers of our nation are not showing any interest for the effective implementation of the Constitution. Dr. Ambedkar introduced caste annihilation system in India. Indian Hindu orthodoxy stood by Manu. Ambedkar stood for Dalits. Ambedkar defeated Manu through constitution and incorporating several articles in it. Ambedkar was successful in fixing the Hindu orthodox people's attitude and behavior as enshrined in their holy books towards others as unjust and punishable through various provisions in the Indian laws and the Constitution. The Constitution of India provided to all its subjects rights to live with honor and dignity, but the caste and untouchability is still playing effective role from various corners of the society. Hence, India shall follow the principles of Dr. Ambedkar and nationalize land and industries. So, the need of the hour is to implement the Constitution in its true spirit. It will enable the Indian society to overcome all social and economic evils that the nation is facing. The Constitution was designed in such a way that all the citizens are equal before it as one man and one vote, one value. Thank you.